Good morning, everyone, and thank you for joining us this morning at WFW Employment Team's second webinar of 2021. I'm Devan Khagram, and I'll be moderating today's session. Those of you who attended our last session will know that we tried to stay away from COVID topics as much as we could last time to focus on other areas of employment law. But with the 19th of July freedom date or terminus date or whatever you want to call it now, drawing closer, and employers are more and more thinking about what they are going to do about returning to the office. So today, our main focus is going to be on that, the challenges of returning to the office. And I'll be looking at the sort of different types of approaches that employers might take. Hannah Myers, who you'll remember from the last webinar, will be focusing on formal flexible working requests because we think there'll be an increase in these. Sarah Gill, who's new to the team and covering for Anna, who's on maternity leave, together with Emma, who's newly joining the team, will be talking more about the challenges of a two-tier workforce and some of the pitfalls around that and things to watch out for. And then finally, Elena Cooper, who you'll remember from the last webinar, will move away from COVID and talk about a couple of recent and significant cases. So thank you for joining us today. Before we get into the topics, a couple of housekeeping points. Please note that your videos and audios will be disabled to minimize disruptions. But if you would like to ask a question, there is a Q&A tab at the bottom, so you can ask your questions through that. And the plan is at the end to address those questions in a Q&A session. Now, if you put your name by your question, and if we don't get round to your question at the end, we can follow up with you afterwards. Another point to note is the webinar will be recorded, so just please note that. And finally, as we go through it, as we have done in previous webinars, there will be a series of poll questions just to try and get engagement and try and get an idea of how you are approaching certain issues and topics. Your answers will be anonymous, so please do participate. It'll be great to see where people are at when we ask these certain questions. Now, going into the main topic of today, the challenges of returning to the office and flexible working requests. Well, as I mentioned, we're moving towards the new normal, and employers are thinking about their plan for returning to the office, from the 19th of July or later. And certainly we don't expect things to return to the pre-COVID environment. Certainly not immediately, and perhaps never. Perhaps, I think there's a good chance that the workplace has changed forever. People have enjoyed the flexibility that they've had, and I think we will see some permanent changes, although I don't quite expect it to be everyone working from home. Now, for employers, I think there are three key challenges as they look at returning to the office. Firstly, employees refusing to come back to the office, at least in the interim, for COVID-related reasons. So that's not to do with wanting to work from home, but because of fear of COVID. Then the different approaches to flexible working. How do you phase people back into the office? What approach do you take? And if that's not what employees like, you might see a rise in formal flexible working requests. And Hannah Myers will be talking about that, as I said. Then Sarah and Emma will be talking about the challenges of a two-tier workforce and some of those pitfalls. So let's get into it and touch briefly on what if an employee refuses to come to the office. Because ironically, I think the removal of all restrictions on the 19th of July actually might create some nervousness in certain employees that perhaps wasn't there before. So if, as an office, you don't have the same strict social distancing, there's no masks on public transport, actually we're seeing the reaction in the press where you've got some people who obviously welcome that, but you've got some people who are actually more nervous about venturing out because of the removal of all restrictions. So, and also not everyone's double vaccinated, so you might get, at least in the interim, a period where people are now nervous about coming back to the office as employers try and push people back in. So as an employer, remember you have a duty of care for the health and safety of your employees. So we always suggest that don't have a blanket approach to people if they are concerned about coming back to the office. Do try and take an individual approach to try and see why someone has particular restrictions or reservations about coming in, because there's a few things to be wary of. There's always the discrimination risk because someone may not be vaccinated or may be particularly vulnerable to COVID because of a disability. And therefore, this could potentially be indirect discrimination. And for disabled workers, you do have to, think about, reasonable adjustments. So do think about talking to that individual and see if there are things you can do to help overcome their fears or concerns about coming in. You might also have certain employees who are afraid to talk about why they've not taken a vaccine or don't want to come into the office and feel more vulnerable. For example, if they're pregnant, it might be very early in their pregnancy and they don't want to say that. So be wary of blanket policies where it's absolutely strict without any ability to have some sort of exemption around it. But what can an employee do if they're concerned? Well, ultimately, if they suffer a detriment of any sort and they believe that there's a serious and imminent danger and have a genuine, reasonable belief that there is a serious and imminent danger, they can bring a claim. And it doesn't matter if the employer disagrees about the danger, if the employee's perspective is reasonable. And we're starting to now see a couple of cases appear in the employment tribunal on this topic. There was a recent case where the tribunal did find that actually the COVID-related reasons could be serious and imminent danger, but they didn't find that the person was reasonable in their belief because the employer had taken so many steps to ensure a safe workplace. And another one, they again found that there was serious and imminent danger, but they said that the employee's motivation behind working from home was actually not because they were worried about COVID, it was to protect their financial position. So tribunals are starting to recognize this, but they are finding ways at the moment, at least, not to uphold claims against the employer. But this is very early days and doesn't necessarily set a precedent in that area. Now, moving on from that, assuming employees are happy in some capacity to come to the office, at least not afraid for COVID-related reasons, as I mentioned, we have seen a rise in home working, flexible working, and not just working from home, but flexible hours. People have had to work around childcare when schools were closed. And so people were working at different times and people have got used to this. And evidence suggests that employees want this continued flexibility, and some sort of hybrid workplace is likely to become much more commonplace. And there is a range of approaches that different employers and organizations are taking. So some are advocating a full return to the office, and we're seeing some of that in the banking sector where some banks have said we want people back or we'd like to have people back, etc., etc. So some people are moving towards, yes, we want pretty much things to go back to pre-COVID. Some, particularly in the tech space, are going fully agile, fully flexible, decide this on a team-by-team basis as to whether you come in or don't come in. Now, that comes with its own inherent problems because you might have some teams doing one thing and some teams doing another, and that may cause some resentment amongst your workforce. So you do need to think about how that's applied and maybe have some guidelines around that. And then there's more of a hybrid approach. And by this, I'm talking more about having a bit more structured, allowing both working from home and in the office, but having it a bit more structured days. So for example, saying specific days you're in the office. So Tuesday, Wednesday, Thursday, you're in the office. Monday, Tuesday, we'll give you flexibility. Or saying we want you in 3 days out of 5 per week, but we don't mind which 3 days that they are. So there's a different types of hybrid working. Now, I think a lot of people are moving towards that, although even around that, there's been some backlash. You might have seen in the press, one tech company was proposing that and the employees were not happy. They said it was too restrictive. But when implementing policies like this, you've got to think about how it might impact other groups of employees in that, for example, if someone's working a 4-day week or a 3-day week, well, if you're saying you need to be in 3 days a week, what does that mean for someone who's working 4 days a week or 3 days a week? So you do have to actually take it a step further and think about that. How does that impact people who are doing compressed hours, for example? Because, just moving on, you should be aware that flexible working doesn't just mean working from home. I know that's what we've associated with it during COVID, but it could mean changing their start and finish time. It could mean reducing the hours of work. It could be fewer days in the office, but doing more hours, so compressed hours, as well as, of course, remote working. And it could be, and generally when you're making a formal flexible working request, that means a permanent change. So at the moment, we've been talking about hybrid models, But what you might find is that if these hybrid models are not appealing to the employee, or if you go as far as some employers and say we want everyone in 5 days a week, well, some people might not be happy with that. They've got used to the flexibility. It works around their personal and family commitments. So you might see a rise in legal, flexible, formal working requests. And I'm going to hand over shortly to Hannah, who's going to talk about this and talk about the formalities of this, because you may recall that there is only certain permissible reasons, which Hannah will go through, as to whether you can refuse formal flexible working requests. There is a formal procedure, and it might be more difficult to justify post-lockdown. So I'm going to hand over to Hannah now, who's going to pick up on that. Thank you.
Thank you, Devan. Good morning, everyone. So I'm going to start by setting out the law. So an employee has the legal right to make a flexible working request. And as Devan said, that's a right to request, not a right to work flexibly. If they've worked with their employer for at least 26 weeks, if they are legally classed as an employee, and if they've not made any other flexible working request in the last 12 months. So of course, some employers might allow employees to make a request even without that legal right to do so. And whatever the position is should be set out clearly in the workplace policy. And we'd certainly recommend putting a policy in place or updating the current one. And this will help ensure that all requests are treated in the same way, and it makes it easier for employees also. So they know where to go, it's clear, and there's no confusion over how to make a formal request. Then of course, once you do have a policy in place, you can share it with employees and train all line managers on how to manage those requests. The next slide, please. So once the employee has made their request, the employer must then look at it fairly. And this might include discussing it with the employee, looking at other options, trying to reach some sort of compromise. Then they need to take into account the ACAS code of practice on flexible working requests, and also whatever is set out in the policy, if there is one. And then finally, they need to make a decision within a maximum of 3 months. So you should look at requests in the order you receive them. So try to make a decision based on whether the business can support the change, rather than making a value judgment about the most deserving request. So look at each request on its merits in the context of the business. We'd also recommend a trial period with clear points for review, and this will allow you to assess whether the arrangements are sustainable for the business. But overall, it's really important that employers act reasonably in considering the request, and they can only refuse it, as Devan said, where one of several permissible grounds apply. Next slide, please. So you'll see the permissible grounds listed on the slide there. So it could include things like it will cost the business too much, there'll be a detrimental impact on performance or quality, or even there's not enough work for the employee to do when they have requested to work. So something like flexible working not being compatible with the culture is unlikely to be a valid reason for refusal. And of course, previously, employers may have refused requests on the basis that it was not possible for certain work to be carried out from home. But of course, given how long lockdown's been in place, it's going to be difficult for employers to refuse requests, especially if that proposed arrangement is essentially just a continuation of something that's been working successfully for over a year now. But of course, this might not have been the case. So you might have received client complaints. Maybe there's been a notable reduction in productivity, or perhaps going forward, of course, as things change, it will become more difficult to allocate tasks fairly between those at home and those in the office. So these are all examples of justifications. But the key point here is that employers will need to provide clear evidence as to why flexibility is no longer possible. Next slide, please. So what's the risk? So firstly, of course, employees could bring a claim under the statutory scheme if an employer refuses a request unreasonably. If applicable, a claim for constructive unfair dismissal, if the employer has conducted itself in such a way to break down the relationship of trust and confidence. And then importantly, employees protected under the Equality Act could bring discrimination claims. And then finally, of course, there's the risk that you will lose employees. So it's likely that the market will dictate flexible working remains pretty entrenched. And this, of course, increases the risk that employees will move to employers which offer more competitive, flexible arrangements which suit them. Next slide, please. So you'll see a few common pitfalls on the slide there, so do's and don'ts. So don't outright reject a request or an application because of a flaw in it. So the better approach there is to inform the employee, advise them to resubmit an amended application. Of course, employees can reasonably expect help and support from the employer during the process, so do provide this. We would also recommend allowing an appeal of the decision if you've rejected the request. And overall, just as Devan mentioned, don't apply a blanket approach. So for example, don't ban all formal flexible working arrangements across the business. Next slide, please. So moving on to discrimination, which Devan touched on briefly. But in the context of formal flexible working requests, of course, you can't turn down a request because of a protected characteristic, so age, disability, etc. But sometimes, of course, these issues are a bit more subtle. So within direct discrimination, you would need to look at whether there is a provision, a criteria, or a practice which is disadvantaging one particular protected group. So you'll see a couple of examples on the slide there. So, for example, the practice of banning flexible working could, of course, end up disadvantaging women who still bear most of the childcare responsibility. So it's really important that there's a clear process for dealing with requests, which is applied consistently across the business, and that you are not just imposing a blanket ban. Next slide, please. So finally, disability. So what if the employee has a disability? So where they make a formal flexible working request because of that disability, and of course this could include long COVID going forwards, anxiety, depression, you could treat this as a reasonable adjustment. So this means you would look at the request in the wider context of the disability and consider how best the business can support the person. So the duty to make those reasonable adjustments is unique to the protected characteristic of disability. And where that duty arises, the employer needs to effectively treat that disabled person more favourably than others in an attempt to remove or reduce that person's disadvantage. And an example of one of the ways an employer may do this is by changing an employee's working hours to allow for additional breaks to overcome fatigue arising from that disability. I am now going to hand over to Sarah and Emma, who are going to expand on the future world of work.
Actually, before Sarah jumps in there, I thought it might be a good opportunity now to do a poll to try and see how you are approaching the return to work. You know, we talked about various options. So on the screen there, you say which approach is your company planning to take to return to the office? There's a full return to the office, fully flexible approach, hybrid approach that I spoke about, or a fully remote workforce. So please do select one of the options, and it'd be interesting to see how you're approaching it, because this will tie nicely into what Sarah and Emma are going to talk about. So that's interesting, and it's interesting to see that a full return to the office is so small, only 5%. Some, almost 20%, are going with fully flexible, but hardly any are doing fully remote. But this concept around a hybrid workforce, 55%, and certainly that's the feeling we're getting. I think yesterday the Bank of England announced that they want everyone to come in 1 day a week for team days. So I think it really is moving in that direction, this hybrid approach. And you know, with it comes dangers, because you know, it's one thing having everyone at home, and it's another thing having some people at home and some people in the office. And I'm going to hand over to Sarah now, who's going to talk about the challenges of that.
Good morning, everyone. So I'm just going to talk about what the future might hold. So it is perhaps premature to herald the return to the workplace as the death of the office, because there are benefits to the office environment. But it is also clear that as a consequence of the prolonged working from home, many organisations are rethinking their working arrangements. And for many employees, the shift to remote working has been a positive and welcome change, and one that they don't want to give up. It is predicted that, as the poll suggests, that a hybrid working model is likely to emerge, which will try and balance the efficiencies gained from working from home with the benefits of the social interaction and the creativity generated with working with people in person. But what may happen in the future world of work is that you not only might have some employees working remotely and those in the office, but you also might have a workforce that is also geographically dispersed over a wide area across the UK, for example, or even internationally. And some of you may have had employees requesting to work abroad. As the ability to work from home is a considerable benefit to employees, in order to remain an employer of choice, as Hannah has already alluded to, organisations are likely to have to offer more desirable working arrangements in order to stay competitive and avoid employees moving to organisations that offer more flexibility down the road, as it were. Next slide, please. Next, I would like to just talk about some potential equality and inclusivity issues with the hybrid working model. Now, I think it's safe to say that remote working has been effective when everybody's been in the same position. We're all in it together and working from home. But what we're predicting is that it could prove more challenging for employers when people are eventually allowed to return to the office, when there are some people working remotely and others in the workplace. This is because critics argue that the head office will always have a disproportionate share of power, and that the employees who are office regulars will have the edge over those who remain home workers. And it's possible that, if it's not managed correctly, that hybrid working model could entrench a divide between those in the office and those at home and create a two-tier workforce, which could result in increased conflict and impair trust in team performance. And at worst, there could be a sense from some employees and managers that home workers are shirking and office-based employees are the only ones that are working. Next slide, please. I just want to touch on some other equality and inclusivity issues. In addition, there may be certain groups of individuals in your organisations who are more likely to want to hold on to home working because of their preferences, their personal circumstances, and in some cases, a key point, their protected characteristics. Unfortunately, it's women still who take on a disproportionate amount of home-based childcare responsibilities, and so you may find that far more women than men opt to work from home. Those with underlying health conditions and disabilities may also approach you to work from home. Similarly, those with caregiving responsibilities, for example, if they have disabled children or elderly parents to look after, may choose to work from home. And again, those people sadly also tend to be female more often than not. And then you may also see a big generational divide. Younger workers living alone in smaller flats with less space, less likely to want to work from home because they also see the benefit of being in the office for their social lives as well and just mixing with other people, whilst older workers and working parents are more likely to be requesting home working. Should home working become the new norm, there are certain groups who, if it's not managed correctly, could become more out of sight and potentially more out of mind going forward. And again, if we don't deal with it appropriately and try and anticipate some of the problems, worst case scenario, they could miss out on work opportunities in the office. They could ultimately receive lower bonuses and salary increases, and they could miss out on promotion by virtue of being more out of sight. And there may also be unintended consequences, such as a broadening of the gender pay gap in organisations. So before adopting a new way of working, and especially if one that you're kind of remote working is going to be long term, employers will need to review their policies, procedures and practices to try and anticipate and avoid some of those issues. They should also educate employees and their line managers on the expectations and parameters of any new working model that is adopted with appropriate messages. And I think that probably what they've been doing during the pandemic, hopefully, and but I think with a more concerted effort even going forward, if it's going to be long term, is that line managers will need to have more regular check-ins with staff who aren't necessarily always office-based. And they'll need to be mindful of the fact that there is the possibility of people being out of sight, out of mind, and not fall into that trap, and make a concerted effort to ensure that all their direct reports are treated equally regardless of where and how they work. Next slide, please. The next thing I want to talk about is employee monitoring. The start of the pandemic, obviously in March 2020, saw one of the biggest changes we've ever seen to the UK workforce and practices. Office-based staff suddenly moved to full-time working from home within a matter of weeks. And home working has brought to the fore the already difficult subject of employee monitoring. And if it becomes the new normal, coupled with advances in technology, I think chances are employee monitoring issues will be on the increase. Now, as you may all know, some managers and organisations do home working really well, others don't. For some managers and organisations, there remains an element of mistrust and a sense that employees may not be working as hard as they should be if they're at home, and even now after such a prolonged period of home working. And there may be a temptation to introduce employee monitoring technology to check what people are doing. Recent reports indicate that 1 in 5 companies in the UK are already either using or considering using some kind of surveillance tech solutions to monitor the workforce. And that, I think, is likely to increase. And we set out on the slide some of the examples of employee monitoring that employers are already deploying. Next slide, please. The key point to think about as an organisation is the more intrusive the monitoring, the more difficult it will be for employers to justify, and particularly if less intrusive methods are available to the employer. The problem is that technology is often introduced with little or no thought to employee monitoring implications. Employers don't always carry out data impact assessments before introducing it. And a lot of the tech is designed in the US with the US labour market in mind, and some of which can give rise to serious employee monitoring issues in other jurisdictions where data privacy is more of an issue, for example, in the UK or across the EU. There may also be data creep with the technology. Employers may innocently introduce it for the purpose of collecting a certain type of data, but when it's introduced, they find that it collects far more than they expected or was originally intended. Although there are many pieces of legislation that impact this particular area, the key one obviously is GDPR. And when employee monitoring goes wrong, the consequences can be very serious and quite costly for organisations, not only in terms of the employment law claims that can arise, but also referrals to the ICO. And as you can see on the slide, you know, the ICO fines have increased recently, and it's up to 4% of global turnover, or £17.5 million. And actually, Barclays is currently being investigated by the ICO for its employee monitoring practices. So now I'm just going to hand over to Emma, who's going to talk about some of the other issues that can arise with hybrid working.
Thank you, Sarah, and good morning, everyone. So it's fair to say the pandemic has affected the health and well-being of everyone to some degree. Working from home brings lots of benefits to individuals, such as increased flexibility in their working days, and this shouldn't be forgotten. In a Royal Society for Public Health survey published earlier this year, 45% of respondents felt working from home was better for their health and well-being, compared to 29% who thought working from home was worse for their health and well-being. However, 29% is a significant minority, and it's important to understand and tackle accordingly the physical and mental health impacts associated with working from home. Employers have had less visibility of the health and safety of employees working remotely, and therefore of physical health issues. Common issues include employees developing musculoskeletal problems, ranging from back issues through to repetitive strain injury as a result of sitting in inappropriate chairs with desks and screens at the wrong heights. Some even sit on beds and sofas. And of course, these issues can be compounded by a lack of regular breaks. Another issue is employees not taking regular physical exercise, leading to low levels of fitness, as well as employees suffering from disturbed sleep, which has a range of causes, including employees working longer hours. With the planned return to the office, these issues may slip by the wayside. However, it's crucial that employers review their current health and safety measures, as employers are still subject to health and safety obligations in respect of employees working from home. In reality, most employers will not have carried out health and safety assessments at employees' homes due to COVID-19. However, with the shift to hybrid working on a long-term basis, employers will have to carry out such assessments. Such assessments could be done virtually, so employers really will struggle to justify a failure to conduct such an assessment. Also, employers should be asking themselves questions such as, are we proactive enough in encouraging regular screen breaks and healthy work patterns? Should we give employees an allowance for IT and office equipment, or organise sending everyone office equipment directly? Many employers will have already done this, but certainly not all. Next slide, please. So I'm now going to discuss mental health issues associated with working from home. On the slides, you can see some common mental health issues and wellbeing issues. There are certainly many causes of such issues. The lack of a commute, for example, can increase the blurring of boundaries between employees' professional and personal lives. In the Royal Society survey, 67% said that they felt less connected to their colleagues, while 56% said they found it harder to switch off. It's worth noting that causes of stress range significantly and may affect certain groups disproportionately. For example, more women than men have had to juggle homeschooling responsibilities. Those living in a household with someone shielding may have been under additional stress. Some may have also suffered a bereavement during the pandemic and had a reduced support network. Next slide, please. Employers can offer support to employees in many ways. It's important for employers to plan for a phased return to the office where possible to ease employees back in gently. We all know how crowded public transport can get during rush hour, so in many cases, it may be that employees' anxiety about return to the office actually relates to catching public transport rather than being back in the office itself. Therefore, if feasible, employers should consider if employees can travel outside of peak hours. And as Devan mentioned, it's important to take an individual approach rather than a blanket approach. Employers should ensure that employees have access to mental health support. Royal Society for Public Health revealed that only 1/3 of respondents to its wellbeing survey had been offered mental health support by their employer, which is concerning. Of course, it may be that employers provide support, but employees are not aware of it, so communication here is key. As I already touched on in relation to physical health, it's important that employers encourage a home life, work life separation. Finally, there's the risk that when individuals return to the office, employers will forget about those who continue to work from home. So initiatives to foster employee well-being, such as virtual coffee catch-ups, should still be maintained. Next slide, please. I'm now going to touch on the right to disconnect. The right to disconnect is a largely continental concept that originated in France and has been adopted by a number of other countries, as noted on the slide. Employees have a legal right not to respond to emails outside of their working hours. Although pressure has been put on the UK government, it remains to be seen whether such a law will be introduced here. As noted on the slide, if the EU does implement a right to disconnect directive, the UK will not be bound by it, as we have, of course, left the EU. Regardless, employers may wish to consider whether they should informally promote a culture which encourages employees not to send emails outside of their working day. It's particularly important that such a culture is created from the top, with senior colleagues setting the boundaries by avoiding sending very early morning or late night emails. And I'm now going to pass back to Sarah, who's going to talk about considerations for managers.
Right, and just before I do that, it would be helpful if we had another poll question, which I would be grateful if you could answer. So just popped in front of you should be another question. So if some of your employees will continue to work from home long term, has your business thought about how its policies and procedures may need to change and what managers will need to do to change how they manage their direct reports? It'd be really helpful if you could answer that. It's something that a lot of organisations are currently grappling with. And as you can see that, it's pretty much half and half. Half of you are thinking about it now and half haven't yet. So I think that's not unusual, I guess. So let's just talk now about considerations for managers and future challenges. So managers may face a number of challenges when managing a hybrid workforce, which might include issues with disconnection and low morale. How do they keep staff engaged and feeling part of it when they're working from home long term? And then performance issues. Well, it's generally accepted that in most industries, tasks have been carried out remotely without a significant drop in productivity or quality. But it's true to say that managers have had less visibility on how staff are performing on a day-to-day basis and whether they're actually coping with their workload. The other point that I've alluded to earlier is potentially a division forming, a split forming between those working remotely and home working in the office, the in-group and out-group dynamics, which can be harmful, that I mentioned earlier. And also the training of junior staff and new recruits. Obviously, during the pandemic, I think they've probably been disproportionately impacted by the people home working. We've had to make a more concerted effort to make sure that we have more check-ins with them and do a bit more kind of supervision with them, because they're not getting the benefit of the day-to-day interaction and listening and hearing what other people around them are doing. And then there's the missed opportunities point. I think this is quite key, really. Home workers are likely to miss out on the benefits of being on site. For example, drinks, coffee meetings, catch-ups, informal discussions, chats with the boss, In the longer term, if it's not managed appropriately and any kind of efforts are made to include people or check in with people on a regular basis, it could lead to a disadvantage for people who are home working if managers prefer those who are on site and neglect to think of those who are working remotely. And obviously that could lead to more employee grievances and disputes. Next slide, please. I think one of the ways that you can handle this, we have the next slide, please, is to introduce manager training. And managers may need support to adapt to a new working arrangements and to changes that they will need to make when managing their teams. And if managers must manage people who work remotely long term, they'll need to be alive to the issue of people not coping with their work and suffering from mental ill health. And they'll need to think about how they adapt their practices to ensure that they continue to team build. Some managers, as I said earlier, manage overzealously, over communication, micromanagers, and others are at the other end of the scale. They're apt to neglect. So the key will be getting the balance right and attempting to curb those kind of extremes. One thing that I suggest that you might want to do, and you may already be doing, is getting managers to reflect on their performance during lockdown may be useful to set and get an opportunity to set the company's expectations when they're introducing a new way of working long term. It'll present an opportunity for manager training and for organisations to flag to managers the do's and don'ts and what they expect them to do and not to do going forward. I think training for managers on how to adapt to manage a hybrid workforce should focus on a number of issues, the primary one being how to ensure that those employees that continue to work from home aren't out of sight and out of mind. And I think that where people are less visible and the pinch points will be the kind of work allocation, promotion, bonus, salary review, team events. I think if you're mindful of those things, you can see off most of the issues that can arise from it. I'm now just going to hand over to my colleague, Elena, who is going to talk about some of the key cases that we've had recently and give you an update on those.
Thank you, Sarah, and good morning, everyone. The first case I'm going to be talking about is Ale and Gill, and it's about potential liability for harassment for employers. And just listening to the team talking about home working, remote working, I just wanted to highlight, I think there could be a suggestion that perhaps discrimination amongst employees could fall away as we are working from home more. I think we need to be very careful just to be aware that discrimination is not going to fall away. It may be reduced in terms of actual face-to-face banter. But of course, if you've got some employees who are working from home, emailing or instant messaging at each other, there may be some discontent that some people are working from home, perhaps not working as hard. And of course, those emails could certainly be discriminatory in themselves. So not only are we not doing away with the discriminatory conduct, but you've potentially got a paper trail as well. So just to be aware of that. So just turning to this case, as you all know already, an employer is potentially liable for harassment carried out by its employees during the course of employment. We are also all aware that an employer may defend a harassment or discrimination claim if it can show that it took all reasonable steps to prevent the employee from doing that act. Now, the burden for establishing the defence obviously falls on the employer, and that burden is incredibly high. I'll be setting out steps that you can take to maximise your chances of relying on the statutory defence. So taking a look at the facts of this case, G was employed by Ale for just under 1 year. He was dismissed in September 2017 and complained that during his employment, he had been subjected to racial harassment by colleague P. An investigation by the company found that P had continually made racist comments to G. G brought proceedings in the Employment Tribunal for race discrimination and racial harassment. It was found that one of his colleagues and 2 managers had been aware of the continual racial harassment. This included comments to G that he should go and work in a corner shop and that he drove a Mercedes car like all Indians. No substantive action was taken in response. The company did have an equal opportunities policy and an anti-bullying and harassment procedure in place. And P and colleagues received equality and diversity training in January 2015 and bullying and harassment training the following month. The company asserted the statutory defence and said it had taken all reasonable steps to prevent the harassment. The tribunal rejected this defence, holding that the training was clearly stale and that a reasonable step would have been to refresh it. The company appealed to the EAT, and the EAT concluded that the training provided by the company was no longer effective in preventing harassment and that there were further reasonable steps that could have been taken. So just to, next slide, please, just to highlight a few points made by the EAT. They noted that the very fact that harassment was happening in a workplace may serve as evidence of the poor quality of training provided to employees. The EAT said that if training was no more than gathering employees together and saying, here is your harassment training, don't harass people, back to work, it is, of course, unlikely to be effective. The EAT also took into account that P believed that what he was doing was no more than just banter, and the managers did not know what to do when, number one, they observed the harassment in the workplace, and number two, it was reported to them. So the EAT therefore agreed that the tribunal was entitled to draw the conclusion it did on the training, precluding the employer's reliance on the statutory defence. So what can we learn from this case? First, if employees are engaging in harassment or in any way demonstrating that they do not understand the importance of preventing or reporting harassment, this should serve as a reminder to refresh anti-harassment training. Having equal opportunities policies and procedures in place is not enough for an employer to escape liability for acts of discrimination or harassment carried out by its employees, and employers should ensure that any training is not simply a box ticking exercise, but thorough and refreshed as appropriate. Even if training is planned to take place within a certain timescale, this should be revised if it is clear that training has been ineffective. And employers seeking to rely on the statutory defence should be reminded that it is a very high threshold to meet. Some reasonable steps will not be enough. The employer must have taken all reasonable steps. And finally, an employer's priority should be on prevention through the provision of regular and thorough training to employees so that you have the maximum chance of relying on the statutory defence. Now, apologies for a little bit of a sell regarding training that we provide, but we do regularly provide discrimination training. And we do recommend that it's actually given from an external third party and on a mandatory basis for your employees. We do recommend that you keep a register, that it is mandatory, that all employees without fail must attend, and a copy of the training notes are kept on personnel files. The benefit of the external training, certainly that we provide, and we can make it quite scary, is telling the employees that actually they can be personally liable. Now, when you actually explain to employees that they could receive a financial penalty for acting in a way which is discriminatory, the message finally hits home that they could be paying to the employee X amount of money, and that could be many thousands of pounds on a personal basis. And of course, the company would then take disciplinary action against that employee, possibly up to summary termination. We're going to move on to the next case now, and next slide, please. And this is in relation to shared parental leave, and we have a poll question on this. So, do you provide enhanced pay for employees taking shared parental leave? Okay, so the results in on that all of the time. So you are paying enhanced is 32%, never 54%, and on a case-by-case basis, 14%. Very interesting. Thank you for responding to that. I'm going to come back to those figures shortly. So just by way of reminder, in Ali in Capital Customer Management and the Chief Constable of Leicestershire v Hextall, the Court of Appeal held that it was not discriminatory to pay men on shared parental leave less than an enhanced rate paid to women on maternity leave. And this case of Price was regarding a man taking shared parental leave and 2 women, one on maternity leave and one on adoption leave. So the facts of the case, as you would expect, pretty simple. P wanted to take shared parental on the birth of his new baby. He was informed that he would only be entitled to an amount equal to that of stat maternity pay, and he brought a claim in the tribunal for direct discrimination. And as you all know, for direct discrimination, a claimant must show that a person, because of their protected characteristic, is treated less favourably than others, and this requires the use of a comparator. The claimant in this case alleged that he was being discriminated against on the basis of his sex, and the 2 comparators he used were the female worker on maternity leave and a female worker on adoption leave. The tribunal immediately rejected the maternity leave element of the claim because of the fact that the intended purpose of maternity leave goes beyond that of merely providing childcare, which they said was the intended purpose of shared parental leave. So they said that the 2, maternity leave and shared parental, were materially different. This then left the question of whether adoption leave was materially different to shared parental leave, and they concluded that it was. The claimant then appealed to the EAT. The first ground of appeal related to the provision of parental leave itself, namely that the purpose of shared parental leave was to allow for the provision of childcare, and that adoption leave should be regarded in the same way. The EAT rejected this ground on the basis that adoption leave extended well beyond childcare alone. For example, adoption leave could be started before placement of the child, and the purpose would be to enable the adoptive parents to prepare both themselves and the environment for the placement of the child. Now, there were 5 factors set out by the tribunal which the EAT concluded were correct in differentiating a claimant on shared parental leave to a female comparator on adoption leave. And these were: adoption leave could commence before a child's placement, shared parental leave cannot. Adoption leave is an immediate entitlement, shared parental leave is not. Shared parental can commence at any time during the child's first year, whereas adoption leave starts at the latest on the date of placement. Shared parental leave can only be taken with the partner's agreement to give up adoption leave, and shared parental must be taken within 52 weeks of placement. So, by contrast, ordinary adoption leave must be taken by the adopter in a continuous period of 26 weeks. So, we've looked at what you guys do in practice. I think it was 32% no enhanced, 54 enhanced, and the remainder 14% on a case by case. Never is more common, not just amongst the attendees today, it is just more common because it can be uniformly applied, and as this case shows, it is not deemed to be discriminatory. Enhanced feels purely on an emotional level more fair, and just as a warning, on a case by case, however you establish that case by case payment, so enhanced shared parental pay for some and not for others, just be very, very careful that you are making that decision on a totally objectively fair basis, just to ensure that you're not going to receive any additional discrimination claims. And thank you. That is the end of the case roundup.
Thank you, Elena. It's interesting to see that there are developments outside of COVID as well going on, and some interesting cases there that you know, employers need to be wary of, and it's, you know, particularly the issue around harassment and how that can actually translate to as Elena said, you know, working from home. And in fact, it could perhaps be more difficult to detect if people are working from home. So some very interesting cases there. Thank you, Elena. We're now in the Q&A section of it. We've got about 10 minutes to cover a few questions. And the first one is we've asked us about vaccinations and how that relates to coming to the office and to the extent that you can make these vaccinations compulsory, or can you ask employees whether they've had it as part of your planning? And there was a lot of stuff in, a couple of months ago about no jab, no job, etc., etc. I think a lot of employers have moved away from that concept, but it was back in the news recently when care homes, it was made compulsory for care home workers to have the jab. And generally, ACAS guidance suggests that you should support staff and encourage them to take the vaccine. That's okay, but not make it a compulsory requirement for being in the office. Provide them with the advantage and disadvantage, because you have to have a really good justification as to why you would do something so intrusive as to ask people to take a vaccination such as this, because you can't force people to take a vaccine as a condition of their job. Is it really a requirement of the job, or can you make it safe regardless? Particularly in the light of the fact that the government have said from it's yet to be 100% confirmed, but 19th of July, restrictions will be removed. So high risk sectors, they've only just introduced it in care homes. The NHS haven't made it compulsory yet, although that may be next. So in an office environment, I would say it's difficult to justify, but if you are in an environment where you feel it can be justified, then do think about some exceptions. Again, we've spoken about the disability risk in different contexts, and that's here as well. If you can't be vaccinated, you might or same for pregnant employees, you might have a situation, you don't want to be in a situation where you're not giving a job to someone who's pregnant and hasn't taken the vaccine, or someone who's disabled and hasn't taken the vaccine, etc. Or there could be religion or belief issues. And the other thing to bear in mind, of course, with vaccinations is the data protection angle. So if you are collecting that data, is it necessary? Do you have a lawful basis for it? But it's special category personal data, so you have to be a lot more careful in the way you process it, what you do about it, and you might, interesting, you might even get scenarios where people are saying, I don't want to come in because X, Y, and Z hasn't had the vaccine. Well, you've got to be careful as an employer that you're not the one passing on that information as to who has and hasn't had the vaccine in your organization, if you go as far as actually collecting that data. A lot of people are moving away from that. They'd rather not have that particular responsibility and are looking at other ways to make sure that their workplaces are safe. And I've noticed we've got a couple of people from our European offices here, and it'd be interesting to get their view on how it's working, in particular in relation to vaccination and coming back to the office. I don't know if we can get them on. Yes, we've got firstly Giuseppe, who's a new partner in our Italian office. Giuseppe, perhaps you can give us insight as to how things are working in Italy in terms of vaccinations and coming to the office.
Thank you very much. I will be very short in time. So in Italy, it is not compulsory for employers to, it's not compulsory for employees to get vaccinated unless in the healthcare services. So apart from that specific sector, it is not compulsory, nor employers are entitled to receive from employees any information about whether they want to be or they have been vaccinated or not. Only the doctor in charge by the employer can ask the employee if he has been vaccinated, if he has not been vaccinated, but is still willing to be vaccinated or not. Also, the employer is not entitled to receive from the doctor in charge any information about the communication delivered to him by the employee. This also if the employee has authorized the doctor to deliver such information. Finally, the question in Italy is what we can do if employees have not been vaccinated, or if the employer is not informed about the status on vaccination of employee. In this case, the employer, if the duties to be performed can be performed remotely, is entitled to have the employee working remotely. If the employee cannot work remotely because his duties are cannot be performed, can be performed just at the office or at the plant. In this case, what we say to our clients is suspend temporarily without remuneration employees until the vaccinated status is sure and allows the employee to be in the same habitat with the rest of the population who has been vaccinated. Thank you very much.
Thanks, Giuseppe. And we've got, I think we've got Victoria as well, a new partner in Madrid. Perhaps you can give us an insight as to how it's going there.
Yes, sure. So very quickly, actually, the situation in Spain with respect to vaccination would be pretty similar to the one that Devan just explained for the UK. There are certain sectors, such as, hospital workers, that to whom it could be imposed the vaccination. But for the rest of the sectors, actually not hiring a non-vaccinated employee or sanctioning or dismissing because there has not been any vaccination could potentially be considered as an act of discrimination, as unlawful. So it's, absolutely not recommended. The truth is that there are two legal rights here, as Devan said also. So the data protection, which is of really, it's a right of a special nature, but there's also the duty to preserve the health of the staff, and it's a legal obligation to impose to the employer. So these two have to be complemented. There's still uncertainty as to how to handle both of them correctly. The final answer might come from the court's interpretation, so we'll have to be looking into that. But for the time being, since vaccination is controlled fully by the state, so employees cannot decide when or where or what vaccination to have, it would be unlawful to or discriminatory to treat them differently, not hire them or act in any way against non-vaccinated employees. So that's pretty much the situation in Spain, and we'll see how the courts respond when this kind of claims come from employers who are worried about having non-vaccinated people among their staff.
Thanks. It's interesting. This is a question that everyone's grappling with, and thank you, Victoria and Giuseppe, for your insights for the different countries. And the rules are, Italy sounds a little bit stricter than the UK and Spain. There seems to be some similarities between the UK and Spain. It definitely is a challenge. There's no set rules around this. People are sort of trying to figure it out as they go along. So it's quite interesting. Now, I'm conscious of the time. We here at WFW are okay to continue with a few more questions, but for those of you who do need to drop off, we won't be offended. Please feel free to drop off and continue with your day. Those who want to stay on for another few more minutes while we address a couple more questions, please feel free to. But just to cover the housekeeping for those who are dropping off, if you dialed into the webinar, if you email events@WFW, we will know that you attended. And tomorrow, all participants will receive a short survey, and your feedback's really important. It helps us determine topics for future webinars and things we can do to improve. So please do respond on that. But so if you have to drop off, feel free. But those of you who can stay, please feel free to stay for a few more minutes as we answer a couple more questions. Now, there's been a couple of questions around formal flexible working and how to deal with this, particularly where you might get competing requests or you get more than one request. And I'm going to ask Hannah Myers, what do you do if you get, say 3 different requests from an employee and you can't accommodate them all, because you might be able to accommodate 1, 2, but it comes to the 3rd or 4th, it might be a bit more difficult. So Hannah, what are your thoughts on that?
So obviously the best case scenario there is that you can accommodate all of the requests. But if you do look at business need and you realise you can only support 1 employee, you've got a couple of options. So number 1, of course, you could see if some sort of compromise is possible. So explain the situation to the 3 employees. And of course, do be careful in that scenario that you have permission from all of them to discuss it. Number 2, of course, you could approve the first request you receive. And number 3, you could choose 1 employee randomly, as long as you have made it clear to all of the employees that that's your policy, that your policy is to make a selection randomly. And another thing, just to note a word of warning, that the decision-making process in respect of dealing with any employee's requests could be subject to an employee's data subject access request, and therefore could become disclosable to the employee. So that's something definitely to bear in mind when you're considering them. to you, Devan.
Thank you, Hannah. And a question we've been asked, it relates to this fully flexible approach or more flexible working arrangements. And what do you do if actually someone makes a request, perhaps a formal flexible working request, to say, I want to work outside the UK? Now, we did cover this in detail in the last webinar, but Sarah Gill is going to give a little bit of insight as to how you might deal with this scenario, particularly in a hybrid working context or formal flexible working request context.
Yeah, thanks, Devan. Working abroad actually, it brings up quite a number of issues for employers to have to think about, actually, and it's not as easy to kind of grant the request as you might think. It's not just a case of someone just packing up their stuff and working abroad, as you can imagine. So you would have to deduct tax from the UK for PAYE purposes, but there may also be local tax and social security issues and liabilities that arise depending on how long your employee is working in the jurisdiction. Another consideration which employers get exercised by, and it depends on what the person will be doing in the jurisdiction, and how long they'll be there for. But there could be a scope to argue that by them working there, even if they're working from their home, as it were, or their second home in Spain or whatever it is, that there may be a scope to say that they have established a permanent establishment for your business in that country, and that might trigger some kind of local corporation tax liability. So I think that's something that you need to consider. There are, of course, in the post-Brexit world, immigration concerns now as well. Does the person have the right to work in that jurisdiction? And also, what impact does them working abroad have on the benefits, for example, that they have in the UK? Their pension, their life assurance, so you have to check all those things with the providers. I think if employees do ask you to do this, my recommendation would be that even if you think about doing it and are prepared to agree to it, that you push some of the responsibility onto the employee. So, for example, yeah, we can grant this, but you need to ensure that you have the right to work in X country. You will be liable for any local tax and social security liabilities that may arise. And yes, employee, you will have to accord fully with any public health guidance that there may be, particularly if they're moving back between this jurisdiction and the UK in terms of quarantine and all the rest of it. So yeah, I don't think it's necessarily an easy one to kind of deal with, and there may be some people that you're prepared to do it for and others aren't. But but if you would like to speak about that in more detail, we'd be happy to do it. It's certainly something that's come up with a number of our clients already. In terms of the discrimination point, I think that as long as you're kind of looking at it in the way that you're dealing with other flexible working arrangements and dealing with on a case-by-case basis, I think you can manage that risk. And it's up to people in terms of what kind of flexible working arrangement and requests that they want to make.
Thank you, Sarah. And I think you're right. It's a particular challenge, and as people start to move towards a hybrid workforce, it becomes a bit more difficult if you're in Spain or somewhere else. If you're having team days and days in the office, it's a bit more of a challenge. And that actually leads me to one of the other questions that we've had is, how do you deal with this fully flexible approach from an employment contract perspective? Well, I think, as well as people talk about a fully flexible approach, I think really you've got to have some guidelines around that. And, you might say, yes, you're happy for people to work from home or most of the time, but I expect, as we move towards this new normal, there will be scenarios where you do need people in the office. You might want team days, you might have certain things. So actually, rather than detailing all of that in the contract, having a policy which sets out how does your fully flexible approach or your hybrid working approach or whatever your approach you're going for works, and rules around that, and setting that out, expectations and examples. And of course, if it's in a policy, there's a little bit more flexibility about adapting that, because people are, this is a new area for a lot of employers. We're trying it out. We'll have to see how it works. Yes, fully flexible, everyone working from home has worked fine. But as Sarah spoke about in her presentation, the challenges of a sort of two-tier workforce might mean that you have to make adaptations of this as you go along. And, as I mentioned, the Bank of England, they've said that we want everyone in 1 day a week so you can have team days. So there are certain rules you might want to think about it. So really, it's you might set out the primary place of work in the contract, but really the rules around it should be in a separate policy. And also think about how that dovetails with a formal flexible working policy. You should still have a formal flexible working policy, and perhaps make it clear to employees that, you know, this is an informal approach, but yes, you've also got a formal flexible working policy if you desire. So making, you don't have to promote it, but I would probably make mention of that in your flexible or hybrid working policy. Thank you for that. I think we've dealt with most of the questions. There are, and we're almost 10 minutes over. A couple of the other questions have been around, will we get the slides? We will be passing the slides back to all attendees. You'll be getting an email with that, perhaps with a survey or separately afterwards. So you will get a copy of today's slides. And I hope it's been helpful. It's certainly a challenge. It's certainly a new world for people in terms of going back to the office and how they're going to do it. And a lot of people are doing a staggered approach and saying, well, we're going to have a bit more flexibility for the next 2-3 months. And then from September, October, we're going to start formalizing things a bit more. And that allows employers to find their feet a little bit and look at and address the problems. It also allows more vaccination, so people are less nervous about coming into the office. So certainly I think there's some benefits in that. And you know, hopefully you found, as I said, today helpful, and thank you. And we'll of course be in touch with you all to invite you to our next webinar when we schedule that. So thank you very much, everyone.